Hey, hello everybody. Thank you for dialing in today for our webinar. My name is Ellen Berge, and I'm here with two of my partners, Dan Blynn and Steve Freeland.
Say hi. Hi, everybody.
Hello. I'm the one without the beard.
All right, that was Dan. Steve was before Dan. So we're here to guide you through an hour or so of telemarketing and texting. This is a webinar that has some CLE credits you can get for it. We've been told that the code that you need for that will be pushed out through the chat section at the end of the program, and if you need a form, we'll send you one of those next week. But with that out of the way, let's get going. So today we're going to cover two basic parts. First, we're just going to give you a lay of the land, basic compliance requirements. For a lot of you, this might be a bit of a review, but it's always good when you sit and think about how the legal framework is. It's a good refresher on sort of all that's included in federal and state legal requirements. So we'll cover that, and then most of the time we'll spend talking about current issues and trends, what we're seeing in the cases, pitfalls to watch out for, nuances perhaps to pay attention to in your programs. And with that, we'll get going with compliance requirements. Anything to add?
And you know, if you have questions, I think there's a function to ask them. We'll try and address them in real time. Otherwise, we will address them at the end or send you an email in response to your own questions.
Okay. And with that, let's get going. So, federal law. Two main statutes here, one enforced by the Federal Communications Commission, the other by the Federal Trade Commission. The FCC side of things is the Telephone Consumer Protection Act, or the TCPA, as we all refer to it. TCPA really regulates and restricts. Most of the TCPA is covering everything that happens before you make the call. So thinking about some do not call requirements, consent requirements to make certain types of calls with an autodialer, for example, and we're going to talk a lot about that today. Consent requirements for pre-recorded message calls, and here, you can see you have to pay attention to the types of calls that the types of phone lines that you're calling on, these types of things, so some nuances there. There are some disclosure requirements under the TSR. There's caller ID requirements. There's also some fax requirements, which we're not covering today, but I was surprised to learn that there's still a lot of faxes being sent in the world. So if you do send faxes, we can update you on that another time. But the important thing under the TCPA is we might just say the word call, but calls include text. And a lot of you are really going to be interested in texting programs. It's sort of the thing that everybody wants to do. So we'll break down texting in particular as we go through this next hour.
And let me just piggyback on that. While the TCPA is enforced by the FCC, it also includes a private right of action, and that's most relevant probably to most of the people on this call. It allows for a private plaintiff to bring class actions in federal or state court, whereas the Telemarketing Sales Rule is enforced generally only by the Federal Trade Commission. There are a couple exceptions that are almost never relevant. But the other big distinction is that while the TCPA governs all types of calls, whether they be telemarketing or informational or transactional, the Telemarketing Sales Rule, as its name suggests, only governs telemarketing calls. And further, the Telemarketing Sales Rule does not govern the mechanism for calling. It still covers the use of pre-recorded messages, but not autodialers.
That's right. So that's a good lead on the TSR side of things. I think with the TSR has a little bit more of our disclosure requirements, for example, to the extent that you might have a subscription-based offer that you're selling over the phone, prize promotions. There are very specific disclosure requirements in the TSR, in addition to the TSR having its own set of do not call requirements, its own consent requirements, particularly in the manner in which you agree to offer terms. The TSR covers that a little bit more. The TSR will cover things like if you're having somebody not pay with a credit card, but by some other mechanism, there's some stuff in there about getting proper consent. There is some disclosure requirements around pre-recorded message calls and robocalls. This is big newsworthy stuff because everybody's getting them and everybody doesn't like them. And this is also a TCPA thing. I think the FTC has been taking a big lead on that area.
A good way to think about these two parallel federal laws, one's a law, one's a regulation. The TCPA is very mechanical, and it generally governs the things that you need to do and the things that you can't do before you hit dial to dial a phone number or send a text. The TSR has both mechanical and substantive elements. On the mechanical side, it parallels the do not call requirements in the TCPA. In fact, the TSR was first to the gate there on do not call, and the TCPA cleaned it up later and implemented the same requirements. But the TSR, as Ellen was just sharing, governs substantive things that must be said on certain calls and also restricts certain things substantively that can be said on calls. So TCPA more mechanical, TSR a combination of mechanical and substance.
All right, let's keep going. And I believe you're all going to get copies of these slides. So if we don't cover every bullet, you can ask us questions later. So we covered a little bit of this. The enforcement is a little bit different. The TCPA, we worry, while the FCC certainly is active in this area, we worry more about the huge private lawsuits, class action lawsuits. These can be really high dollar figures. The reason is because the plaintiff's lawyers go for the full penalties that they can get from it. So it's up to $1,500 per call or text. It's really just $500, but you can triple that if the violation was willful or knowing. And willful really only means that you hit the button. You didn't have to intend to violate the law. You merely hit the button to make the call. So you can see how damages can skyrocket. Big class action lawsuits, as we said, many millions of dollars could be at stake. So, you need to take lots of care there.
Yeah, and just to add a little bit of flavor to that, if you aren't concerned, you should be if you're engaging with consumers or customers over the phone. Just last year, there were verdicts entered of $267 million and $925 million in two separate class actions out in the Ninth Circuit, one involving collection calls and one involving telemarketing calls. So these penalties can add up very quickly.
Mm-hmm. You can see on the quickly on the FTC side of things, their penalties also add up, and they will actually look for many reasons to look for a TSR violation if they can. They've had some. The agency has had some issues lately with bringing some cases under Section 5 of the FTC Act, so if there's any sort of telemarketing involved, it's been a little bit easier for them to just allege a violation of the TSR. That's a nuance. I think we don't have a lot of time to get into it, but we can talk about that as we get time.
Just go back real quick.
Sure thing.
So while there is no statutory cap on damages in the TCPA, on these large, as you can see, it's $500 per violation call or text. If you've got one campaign that goes sideways for whatever reason, you're talking about the company's rear end being on the line or potentially in bankruptcy. And so there is sort of a Hail Mary that's out there, which we are actively litigating in a couple of our cases, which is while there is no statutory cap on damages, we still have the due process clause. And there's an old 1919 Supreme Court case that says that statutory penalties can be aggregated such that it has the effect of depriving a party of due process of law. Now, and there are varying factors that go into that, the degree of culpability, the ability to pay, and things of that nature, all of which are very subjective, and all of which, unfortunately, is left in the hands of judges, generally not jury, because it's an equitable reduction of a statutory damage award. And so there was a recent case out of the Eighth Circuit, the Golan's decision, which affirmed a district court's significant reduction in damages. Problem there is it was still, a very significant award even with the reduction, because again, it was one campaign that went, that there were a number of calls made over a few days, but you do the math, it added up to a lot, and even with the reduction, it was still a lot. So don't bank on the due process argument, but if you find yourself at the outset of a case with a lot of exposure, as part of your settlement negotiations, you may consider throwing in that due process argument with the plaintiff's lawyers, because the court, they'll be rolling the dice on that as well. If the case is litigated, and even if they win, there still could be a significant reduction. So that argument is out there, but I wouldn't hang your hat on it.
Okay, let's move sides. We're going to go to the state law, just to mention here, because while a lot of our discussion today is going to be on the federal and TCPA in particular, you really don't forget about the states, because almost every state has their own telemarketing rules. Some of them maintain their own state-specific do-not-call lists in addition to the federal list. Some of them have registration requirements, and while there are exemptions that might apply, the exemptions can be different among the different states. They may or may not apply. Registration might require bonding and all sorts of other things. And we, over the years, have gotten letters from states saying, hey, we think you're engaged in telemarketing and we don't think you're registered, so explain to us why you aren't registered. And while I do think we see more of that coming up when the calls are auto-dialed and pre-recorded message calls, I've responded to those letters when it's just a regular live operator type of outbound call. So keep that in mind. Some states require that you have policies and be able to show those types of things.
Yeah, and not surprisingly, California has waded in with its own specific requirements. So, for example, under federal law, your calling time restrictions for telemarketing calls is 8 a.m. to 9 p.m., local time of the party you're calling, not where you're calling from. In California, however, you can't use an autodialer until after 9 a.m. So it's between 9 a.m. and 9 p.m. where you can use an autodialer to make calls in California. So that's a prime example that comes to mind, where there's a technological restriction that could impact or expand, even if by an hour, your potential liability under state law.
All right, let's keep going. So let's start with the TCPA consent requirements for informational calls. And these are going to be consent requirements that come into play when you've got an autodialer that you're using. And we're going to talk in a minute about what's an autodialer, so just sit tight on that issue. But Dan, why don't you start here and cover sort of what are informational calls?
Sure. So, let me just take one step back. The type of consent that you need is a function really of three things: the type of call or text that you're placing, and that's what we're talking about now, the difference between informational and telemarketing calls, how you're placing the call or sending the text, and to what kind of number you are, whether it's a cell phone or a residential line. But informational calls at their core, they don't contain any sort of solicitation or marketing content. They are, as the name suggests, purely informational, such as the status of shipping of a package.
Your prescription's ready to be picked up.
Your prescription's ready. Things of that nature, school closings, although arguably that might be something else. That might be an emergency call. But those are the pure informational, non-telemarketing kinds of calls and text messages. There's also a concept of the dual-purpose call, and that is ostensibly an informational call that also has a marketing component to it. And the plaintiff's bar has gotten creative and made some arguments that, on their face, purely informational calls that, for example, might include a link to a website, and at that website, someone, if they so chose, could navigate to a commerce page, and purchase a product. Well, that makes the whole call or message a telemarketing call. So, be cognizant of that. Telemarketing calls, which we'll get into in a minute, promote or encourage the purchase of goods or services, and typically need a higher level of consent, again, depending on how the call is placed and to what kind of number. But for informational calls, generally, you only need a lower level type of consent called prior express consent, which is deemed to exist whenever a consumer gives you his or her telephone number voluntarily. And it lasts until the consumer revokes that consent. There's no expiration date on consent, and that's an issue that's been litigated throughout the country. Prior express consent, again, is deemed to exist whenever a consumer gives you their phone number. You don't need any special kind of language or disclosure. You don't need a checkbox. It simply exists by virtue of the consumer providing their number. It can be verbal or oral. It's better if it's if there's some sort of record that you can keep of that consent, of that consumer providing consent, such as a lead page online where a consumer types in their phone number, or perhaps a card where a consumer provides writes their phone number down and the like. But the important thing to remember with prior express consent is that the consumer has to voluntarily provide you their phone number. You can't capture it from a caller ID. You can't scrape it from the internet or a phone book. And you certainly, and we included this as the last bullet on this slide. It seems commonsensical, but we've actually seen this issue arise. You can't get prior express from someone saying they don't want to receive calls anymore. That's a no-no.
All right, so let's move on then to the consent requirements when your message or call has a marketing purpose.
Right, and so as Dan was saying, it's this distinction between informational versus marketing is critical. If the standard is, if the message is designed to elicit a purchase of a good or service, it's deemed to be marketing. Courts have generally taken a broad view of what that means, meaning that they'll sort of bend over to find a marketing purpose. However, that being said, courts are also mostly commonsensical, and if an informational text, as Dan was saying, leads to a website and you can navigate 7 pages to get to a purchase page, most courts would say that's not a marketing message. So what are the easy the easy things that constitute marketing messages? Click on this link within the next 2 hours to get 25% off the latest line of perfume. From a car dealer, we're running a special 25% off for the next 2 days. Come in and buy a car. These are all very clearly marketing messages. We can also get into what are called mixed messages, and this is very dangerous, and we've seen this with a number of cases where you have an informational message combined with a marketing message, which is I order something from an online merchant. It's a widget, and the merchant texts me to confirm that my widget will be delivered tomorrow, and also says, hey, also great news, click on this link and you can buy this new widget we just came out with at a discounted price. Now, if I've only given them my cell phone number in connection with my checkout at purchase and I've done nothing else, that's a TCPA violation if it was sent using an autodialer, because I have not provided prior express written consent. Simply putting my number into that checkout form does not constitute prior express written consent. Okay, so what is prior express written consent? We've got the elements listed right there on the bullets there. There needs to be some magic language in the consent. It needs to be clear and conspicuous. The language needs to say that, in some sense, I consent to receive automated telemarketing calls and texts at the number provided and understand that my consent is not a condition of purchase. Those are the magic elements that need to be included. There is no set magic language to tick off those elements, but those are the elements that need to be included. And then nearly everything is done with a digital signature nowadays, and we'll talk a little bit more about that in a second, but an old-fashioned wet signature is just as good.
Yeah, and let me just add one thing to what Steve said. While there is no magic language, there is a definition of prior express written consent in the TCPA itself, and we've seen kind of a little bit of an alarming trend over the last year and a half, where the plaintiff's bar has kind of brought TCPA class actions alleging that the failure to include the word marketing or otherwise clearly advise that the kinds of messages or calls you'll be receiving are telemarketing calls or messages, that is ipso facto not prior, that violates the prior express written consent rule, and therefore you violated the TCPA. There's a favorable decision of the Northern District of Illinois at the beginning, I think, of 2019 or end of 2018 on this issue. The issue has been briefed up in California, but that case settled before the motion to dismiss was decided. But just be aware that you really do need certain elements, although maybe not required language.
So with that, let me say that a lot of people will add, and sometimes their carriers or their providers require them to add things like message and data rate supply, how many messages you can expect to receive, reply stop to cancel, help for help, things like that. What I always tell people is that while those are actually nice to have, they're not legally required. But again, you may contractually have a requirement to add them, but it's not required by the TCPA to include these types of things.
One benefit of including the reply stop to cancel and having that be captured is you're providing the consumer with an easy method to revoke consent. And there was a case out of New Jersey, and there's been a couple that have been consistent with it, where a plaintiff signed up for a department store bonus program and provided consent, express written consent, to receive automated texts about offers and deals from that department store. And at the end of the text, the department store said, reply stop to cancel. And the plaintiff replied everything but stop, used every other word, every other convention to try to revoke consent other than stop. And what Dan and I believe was just a complete setup for the company to be sued, because she then filed suit and claimed, well, I revoked consent by texting back, I didn't want to receive these messages anymore. And they, the company, are prohibited, and this is technically correct, from restricting the way in which I can revoke consent. They need to accept my consent that I can give on using any reasonable means. That's the standard. A consumer can revoke prior consent using any reasonable means. And the judge looked at this and said, are you kidding me? They provided you the reasonable means, and you chose to use all of these unreasonable means to try to opt out. So I'm finding that your revocation was ineffective and that you never used the reasonable means, the easy means that was provided to you. So that's an incentive to keep that reply stop to cancel at the end of your text messages, and then, of course, honor them when they're sent back. And that on the receiving end, the business's receiving end can be done with automated bots and algorithms and things of that nature to opt them out of your calling program. But that's an incentive to have reply stop to cancel on your text messages.
And we got to keep it moving through, but I do want to make one more point that's on this slide, is keeping records of consent, keeping records of the disclosures you're making, the consent that you're obtaining and recording, whether you're getting somebody's consent online or over the phone. Make sure you have worked that out, because if you have a program to get consent and it's all what it needs to be, and somebody files a complaint about you or threatens that, you have to be able to prove that you had their consent. So with that, we'll keep moving. There's a couple of examples we put here that are out there, but these were not litigated to my knowledge, but they will give you a sense of. They look pretty good to us, and they will give you a sense. We would probably defend these, and they'll give you a sense of what you need to include. And you can see it's not super long. I mean, everybody's really worried that these disclosures end up being like really long and convoluted, but it's not. I think consumers are starting to get used to seeing these types of things now. But often they appear in a form. Somebody inputs a phone number, and then a checkbox is recommended, not necessarily required, but I think recommended because it evidences that action to agree to receive the calls, and then sort of separates the agreement from submitting the form in general and things like that. But go ahead.
Yeah, and so, one point on the checkbox, and first of all, these are all, I think, very good examples of prior express written consent. Frankly, some you could probably do well with fewer words. A lot of these, especially the second example, hit on the CTIA's requirements that Ellen was mentioning earlier. About frequency or replying help, putting that in the disclosure. You don't need that for TCPA purposes. You might need it for CTIA if you're using a shortcode. But getting to the checkboxes themselves, the key with prior express written consent is evidencing that the consumer has given that level of consent. And the consent has to be clear and conspicuous. It has to be essentially unavoidable. Where a checkbox is necessary is if the consent language is below a submission button, like the submit button on the left, the sign up button on the right. If you put your consent language below that, that's where you need a checkbox, because the argument, and in fact there was a certified class action, and this issue is being litigated elsewhere. Perfectly good consent language placed below a submission button, a consumer can say, I didn't scroll far enough down on my iPhone or on my computer screen to actually see that message. If the language is above a submission button, even without a checkbox, a consumer necessarily has to have scrolled through it to go to the submit button. So be aware, checkbox not required if it's above a submission button, generally required if it's below, otherwise you run some risk.
And two quick points. As Ellen was saying, if you are sued for a TCPA violation and you want to have a defense of prior express written consent, it's your obligation to prove it. It is an affirmative defense in nearly every court now. There are third-party companies out there now that have developed technology that can help with that evidence. One is called Jornaya. There's another that's called Trusted Form, where they essentially take real-time video images of each consent that's being provided, that's tied to the name and the number of the person providing it, such that if you are sued, and I think both of these companies do this, they would have someone that would swear out a declaration that said that they were retained, that their software captures a real-time video of consents on xyz.com, that on this date a person came and put this name and this phone number and consented to this language, and here's the video, true and correct copy of it attached, here to in a zip file or in a thumb drive, and that can be very powerful evidence to get cases thrown out early or dismissed voluntarily early. So again, that isn't necessary in order to have valid, evidence of valid consent, but it is becoming the best evidence of that type of consent were you to be sued. And then the second point is for our lead generation folks, in your consent language, you should list the people that the companies that you're getting consent for by name. It's okay to say partners and use a hyperlink, as long as that hyperlink doesn't contain 100, 200 different companies that you're trying to get consent for. You will be decreasing the argument that you have clear and conspicuous consent for those companies to call that consumer. I'd also recommend adding in language that says that the consumer is consenting, that they understand that if they want to opt out, they need to opt out as to each company that's listed in the consent. Because there could be an argument, this case hasn't come yet, but plaintiffs' attorneys are creative, there could be an argument that from the consumer side saying, I provided consent for these 20 companies to call or text me all at once. Why couldn't my revocation should have been effective as to all of them at the same time. So you should make it clear to the consumer that they've got to revoke and opt out as to each company they're consenting to be contacting by.
All right, I'm actually going to skip this next slide. Again, you can all ask us questions if you need it. Let's move on to current issues and trends. Let's get to the heart of some of these issues that are frequently litigated. And starting with what's an autodialer, we have two slides on this. So this one just sets out the basic definition as it was written, in 1992?
91.
Before
91.
cell phones were really, prevalent, and probably, look like, what is this little machine that we have here? So
AT5000 from The Simpsons.
Yeah.
It's the Happy Dude episode. Steve and I we've got, pretty weak social lives, so we watch a lot of TV, but it's from the Happy Dude episode of The Simpsons, and I love this image because I actually do think that's the quintessential autodialer that just flips numbers one at a time, especially as it existed in 1991. But for all you trivia geeks, the AT5000 was Professor Frink's very first patent. patented invention on the show. But the issue of what is or is not an autodialer, every client wants to know if a platform is or is not an autodialer, and unfortunately, right now that question is shrouded in I think the language from various courts is significant fog of uncertainty. And the answer kind of depends on where in the United States you are, because in the Ninth Circuit, out in California and the West Coast, if you are dialing from a stored list of telephone numbers, regardless of how those numbers are assembled, that may well be an autodialer. On the flip side, if you're up in the Third Circuit in New Jersey and Delaware and Pennsylvania, if you're dialing from a stored list of numbers, the phone numbers must have been randomly or sequentially generated. So if these are a cultivated list of phone numbers and you're dialing them, that's typically not an autodialer. Now, under any court's interpretation of what an autodialer is or isn't under the TCPA, if there is a significant or a requisite amount of human involvement at the dialing phase and or before, the platform likely will not be held to be an autodialer. That begs the question, what's enough human involvement, and there are court decisions on that. But the long and short of it is, no one really knows yet. There is a large FCC proceeding that's been ongoing for a little while, designed to address all of these issues surrounding whether or not, or what constitutes a automatic telephone dialing system and what doesn't. There are, I can give you my conspiracy theory why that order hasn't issued yet. I'm happy to take that question offline, but I'm not so sure that we'll get a decision in the next week or two, to put it mildly.
Yeah, it's an election year, and we're unlikely to get movement on this particular proceeding, is our guess, until after the election.
All right. So with that fog of uncertainty, I mean, what I usually say with my clients is that, presume you're using an autodialer and get the consent, because, unless it's truly you're manually dialing or there's clear human intervention, it's a tough argument.
Right. Basically, the only things that for sure are not autodialers are your off-the-shelf smartphones, and I'm not talking about a smartphone with a dialing application, because that has its own issues, and a rotary telephone. Courts and the FCC are in agreement on all of those right now.
All right, let's move to the next issue. So, if I've consented, can I take it away?
Answer is generally yes. In fact, there's a strong presumption that it's always yes, with one exception I'll talk about in a second. And as I was previewing earlier, you'll see under that second bullet, consumers cannot game the system. This is why it's advisable to have some opt-out mechanism, particularly in your text. As Dan was saying, there's no expiration date on consent, prior express written consent, or prior express consent for informational calls. Now, the question becomes, however, in instances where consent may not be revocable at will by the consumer, if you've got a bargained for exchange. And so if I sign a financing agreement for a car, and in that agreement is a clear term that I agree that I will be contacted with an auto dialer, and it's a provision in a negotiated bargain for contract, at least in the Second Circuit, that consent is not revocable by the consumer. It would need to be agreed to in writing by both parties. And so, that's the rule in the Second Circuit. What is and what is not bargained for consideration is a highly debatable question of fact in most cases. I would not rely on this, particularly if you're just doing run-of-the-mill online sales transactions, to be a defense. And as we note there, not all courts even agree with the Second Circuit there. But if you're up in the Northeast, you may have a defense on that.
And let me just add to that. The really frustrating thing is, you will have the same court, but two different judges down the hall from each other, and this has happened down in the Northern District of Ohio in 2018, go opposite ways. One has adopted the Second Circuit opinion or view, the other hasn't. And then, to further complicate things, there's the middle ground, where at least one court, the Northern District of Iowa, in a case at the beginning of last year, said, we're rejecting the concept of the inability to revoke bargain for consent underlying a contract. However, if that contract also says to revoke consent, call this number or email this address, well then, in that case, the consumer has to follow that means of revocation. However, that again runs up to the concept of, runs up against the idea that a seller can't unilaterally set the terms of revocation. So as you can tell by now, because your eyes are probably spinning, the TCPA and all of these issues that underlie the TCPA, it's just an absolute minefield. One thing to keep in mind if you ever do run into a consumer arguing or a plaintiff arguing that the Second Circuit positions should be rejected, a lot of the cases that have rejected the Second Circuit position have arisen not in cases involving a contract, but in cases involving applications. So you don't have the bargain for consideration principle underlying a negotiated agreement. So just be aware of that, and that's a subtle nuance that plaintiffs gloss over, some defendants just don't appreciate, and oftentimes courts will gloss over as well.
Yeah, to provide just two quick points of clarity and sort of a middle of the presentation summary here. While there is a lot of uncertainty and disagreement amongst the courts and the FCC, as Ellen said earlier, the easiest way on the front end is to get the consent, is to get prior express written consent for everything that you're doing. And on this side, on the revocation side, provide the easy mechanism to opt out if you're texting. If you're not providing that, you should advise and instruct your customer service and your telemarketing folks who are receiving inbound calls from consumers or inbound emails that they should interpret basically any dissatisfaction with receiving calls or texts from the consumer as revocation. Err on the side of interpreting a consumer's, however they're saying it. I don't like getting these calls. You know, that you should interpret as being revocation. Or I was called in the middle of the night last night with an offer. Consider that revocation and disposition them do not call. You should always err on the side of dissatisfaction from the consumer at any level about the calls or texts they're receiving as being a communication of revocation. That's the safest way to avoid, future liability.
All right, let's go to the next issue. So what if you call a wrong number, or you actually think that you're calling the right number, but lo and behold, the person you thought you were calling gave up their cell phone and the number was reassigned to somebody else?
Yes, that's the reassigned or wrong number concept is a favorite among the plaintiffs bar right now because it allows a consumer to say, well, you're saying you've got a lead form with my phone number on it. I didn't give it to you, or you misdialed someone's phone number by a digit, so you've called me without my consent. You have violated the TCPA. Fortunately, there's the defense to that, the standard for determining liability for autodialed or pre-recorded message calls to wrong or reassigned numbers is the reasonable reliance standard. And what does that mean? That means that it was reasonable for a seller to rely upon the consent that it had or that it thought it had when it received that consent to call a specific number. How that plays out in reality is you have called a telephone number a number of times. Sometimes a consumer picks up the phone. More often than not, they haven't. But you don't know that the consent that you received is no longer good or that you're reaching the wrong number. At least two courts, the Rourke Court and more recently, just a few weeks ago, the Sando Court in Massachusetts, have confirmed that, no, the seller could reasonably rely on the consent that it thought it had. And unless there's an indication that the consumer, the recipient, advised the caller that it was calling a wrong number or a reassigned number, well, then the defendant prevails. And this reasonable reliance standard is it's also been the standard that, if you look through the FCC's pronouncements, especially through its public notices regarding what is or is not an autodialer, the FCC has said this is the standard. We want comments on whether we should maintain this standard. So I would argue that this is not just the standard created by the courts, but it's one adopted by the agency tasked with construing the TCPA in the first place.
All right. So real quickly, what is this reassigned number database we've been hearing about for a little while now?
So that's something that's still in its design and implementation. It's been approved by the FCC, and they're trying to find the right government contractor to run it and deal with a lot of the mechanical issues and the technical issues of how it's going to operate. Once it does go operational, just like the Do Not Call database, you'll be able to subscribe to it for a fee. And it will increase the strength of any defense of reasonable reliance if you are subscribed to it and are using it to determine whether or not you're calling a reassigned number. And so more to come on that, but it's a government operation, so we're not going to hold our breath on when it'll be done. There are some deadlines that are imposed by the FCC's order, but those can be relaxed based upon the types of progress that they're making in the design and in the implementation.
Yeah, and just to give you some idea of dates, this reassigned number database was adopted by the FCC in late 2018, and there were a bunch of technical analyses and pricing structure decisions to be made in 2019. Not surprisingly, that date got pushed out to now, this month, January 2020, with an additional month, February 2020, to figure out how the pricing structure would work for the reassigned number database. I think that I've seen people comment that they think the earliest possible deployment is likely summer of this year. I wouldn't hold my breath on that, right? But just know that, in theory it's coming soon, but it may be still another year or so.
All right, I'm actually going to skip ahead 2 slides. We're going to come back to vicarious liability, but I want to hit Ringless voicemail because we actually had a question about Ringless voicemail and is it covered?
Yeah, so Ringless voicemail it's a technology that has been floating around for a while now, and I get questions from clients all the time about it. I still have a tape deck in my car, so I'm not the best expert on technology, but I do know enough to understand how it conceptually works. It allows for a voicemail to be dropped into your cell phone voicemail box, where your phone doesn't ring. You all of a sudden get a notification that you have a new voicemail. You might have seen these already. You get these notifications, but the voicemails and are not carried over the wireless network. And so the argument is, well, a call must be carried over that network, and if it hasn't been carried over that network, it's not a call subject to the TCPA in the first place. The Saunders case noted on the slide from 2018 flat out rejected that and said, nope, ringless voicemails are calls subject to the TCPA. Last March, another court down in the Southern District of Florida reached that same conclusion. There are certain states that have amended their telemarketing laws to apply expressly to ringless voicemail. And, you could still make the technical argument, but if you think about it, it's kind of a nasty little technology. I don't like getting, voicemails that all of a sudden show up on my phone. Probably most of you on the phone don't. I mean, the concept underlying, the TCPA is consumer expectations and avoiding consumer complaints. And if you're doing that, you're doing an okay job. So be cognizant of that when you evaluate ringless and other kinds of technology.
Okay, moving ahead, just 1 slide. But since we're on cassette tapes and technology, let's quickly hit in-app messaging and push notifications.
Right, and so we haven't seen a TCPA case that addresses in-app messaging. There are strong arguments for why they would not constitute calls. But again, plaintiffs' lawyers get creative. But for now, we haven't seen any cases brought under the TCPA for in-app messaging. I would, somewhat off topic for this presentation, but if you do have apps and you're communicating through apps, I would do what most major apps do, which is get that consent when they download the app, that they consent to receive in-app messaging and push-downs and things of that nature. Nearly everyone, I think, just clicks through that, at least most of my teenagers do. Then at the state law level, there are a couple of states, Connecticut and New Jersey are the ones that we've identified. They've got some weird language in their telemarketing acts that a plaintiff could argue covers in-app messaging. We have not seen any cases litigated under those provisions. To the extent that they were brought, they could only be brought on a state class-wide basis in both of those states. That's not to say that there still couldn't be significant liability, but one of the deterrents from the plaintiffs filing cases under those statutes could be that the class just wouldn't be big enough in those states. But that's something we're keeping our eye on moving forward.
Yeah, and while we're on the concept of new technology, something that's not on the slides, but I'd like to raise is this technology called soundboard technology. And what that is for folks who don't know what soundboard technology is, it allows you, a live human sitting on a phone, to have a telephone conversation with a recipient, but instead of the sales representative using his or her own voice, they conduct the conversation using these pre-recorded audio snippets. And there have been several cases decided in the last year, and a couple more pending out there, that have argued that the use of soundboard technology constitutes the use of a pre-recorded message. Even though when the TCPA was passed, this technology didn't exist, and if you look back at the legislative history, the concern was about picking up the phone and hearing a non-interactive, from start to finish, message play, basically turning your telephone from a two-way communication device into a one-way audio receiver. Most recently, just in December of last year, the Northern District of Illinois found that soundboard constitutes a pre-recorded message. Like I said, there are other cases pending out there throughout the country. And just so you know, there are two petitions pending at the Federal Communications Commission asking for clarification or confirmation that soundboard technology does not constitute pre-recorded messages.
Okay. Well, if we have time, we can come back to shaken and stirred. That's for after 5 p.m. Okay, let's go back and pick up vicarious liability. So this is an interesting situation, and we're running short on time, but an important one to cover because so often we're hiring somebody to make a call on our behalf, or maybe we're working with lead generators who are making calls. There's all sorts of scenarios where you might not have actually been the one that dialed the call, but are you responsible for it if somebody did it on your behalf?
So this is a very hotly litigated issue right now. Dan and I have got a couple of cases on this issue. Despite Congress admonishing the two agencies, the FTC and the FCC, to interpret the Telemarketing Sales Rule and the TCPA consistently and complementarily, they diverge very greatly on this very important issue. The FTC's view of vicarious liability, if you are an advertiser, meaning you're selling a service or a good, and you hire a telemarketer to advertise and sell that good, you're liable. That's it. That telemarketer violates the TSR, you are liable for its violations, and as we saw in the earlier slide, penalties per call there are very steep. The FCC's view, which emanates from a decision called the Dish decision several years back, is in theory supposed to be more stringent. And we've got the quotes there from Thomas v. Taco Bell and a couple of, which is a case that interpreted Dish. And what you need under the FCC's view of vicarious liability is that the advertiser would need to be a principal and the telemarketer its agent. You would need to show, as a plaintiff, a classic principal-agent relationship or a principal-agency relationship through apparent authority or ratification. Now, what does all that mean? Well, let me just break it down to sort of the elements that courts look at here. Principal-agent relationship connotes an element of control. It connotes an element of significant control by the principal, in this case the advertiser, over the calls being made and the conduct of the telemarketer. And the things that courts will look at to determine whether or not a principal-agent relationship could exist are, did the principal write the scripts that the telemarketer is using? Did the advertiser actually write the scripts that the telemarketer is using to try to sell the good or the service? Did the advertiser train the telemarketer's agents? Did the advertiser have access to the telemarketer's database? Was there sharing of information? Did the advertiser have the right to fire telemarketing agents that went off script? And so you would think that by an advertiser exerting that level of control over the telemarketer, they're actually behaving more responsibly because they're overseeing what the telemarketer is doing and not doing, in theory, to make sure they're complying with the law. It can turn out to be the reverse. The more you're overseeing them and the more you're controlling them, the more you're opening yourself up to liability. And again, because of the mechanical nature of the TCPA, it can be very easy for a telemarketer to violate it, thereby exposing the advertiser to TCPA liability under a vicarious liability theory. Now, another important point here is this, again, can be very fact-intensive. And it is also yet another point where the courts diverge. The Taco Bell case, there's another case out of the Ninth Circuit where, Dan and I are reading the decision, and it looks as if, well, not Taco Bell, but this other Ninth Circuit case where it looks as if they're going to go and find vicarious liability. I mean, the advertiser was setting the times for work for the telemarketer, had involvement with training, all of these elements of control I was just talking about, and the court still found no vicarious liability at the summary judgment phase. Other courts, federal judges, have erred by concluding that even where there is a degree of separation, where it's literally the advertiser hires the telemarketer and says, telemarketer, you're going to control all the manner and means. You're going to select the dialing technology, you're going to select the phone numbers, you're going to write the scripts, you're going to do all of that. At least one judge has concluded, again, we think wrongly, that constituted vicarious liability, that constituted principal-agent relationship, essentially because the advertiser hired the telemarketer, had evidence of a few complaints of TCPA violations, and that was essentially enough in the judge's view. And so this can be very fact-specific. The advice point here, make sure your contracts are clear. And again, this could depend on where you're sued, but I would definitely, make sure your contracts are clear as to who's going to control the manner and the means of the campaign. If you're an advertiser that wants that control because you want to be hovering over the telemarketer to make sure they're not violating the TCPA, make sure that's clear. If you want to go the other way on it and place all the TCPA responsibility on the telemarketer, make sure that's clear. Address this in your contracts because very often this can come down to what the contract requires and what the contract says between the advertiser and the telemarketer.
Okay. There's a slide in here that you all can read when you get them. This is not vicarious liability. It's actually maybe even the flip-flop of it, but under the Telemarketing Sales Rule, there is a provision that can hold somebody responsible for violating the Telemarketing Sales Rule as if they had made the call themselves when they were a third-party service provider. They provided leads. They provided scripts. They sent out the mail. They were the fulfillment house. Payment processors get hit with this all the time. So it's a very low standard. If you provide some assistance or you facilitate the activity of a telemarketer that violates the rule, and you sort of turn your head the other way. You think that what they're selling by phone is not done well, but you nonetheless, continue to support them, that could make you responsible in that way. So we can cover more on that any other time if you want to reach out. So with just the last few minutes, why don't we cover this last issue? Is this everybody's saving grace? Is this a potential?
Well, we'll have to see. We have a Republican-dominated Supreme Court right now. But let me set the stage a little bit. There have been, over the last year, a series of appellate court cases to have found that one provision of the TCPA, it was introduced, the TCPA was amended, 2015 or 2016, to allow for auto-dialed calls without consent in an effort to collect a government debt. How nice. Somehow the phone rings differently when you're calling to collect government debt, but as opposed to your own or someone else's. But the Fourth Circuit in two cases, at least in the Ninth Circuit and maybe some other courts, found that provision of the TCPA violated the First Amendment because it treated speech differently. And the Supreme Court just earlier this month, I believe, accepted cert of the case that came out of the Fourth Circuit, the American Association of Political Consultants case, to decide whether when the appellate courts struck down that provision of the TCPA, but left the rest of the TCPA intact, they erred, and whether, because one provision of the statute is unconstitutional, that makes the whole statute unconstitutional. If the Supreme Court finds that, because that the appellate courts erred and that they should have struck the whole TCPA as unconstitutional, and in fact, the TCPA is unconstitutional, we'll be in a brave new world. I suspect that Congress will jump in fairly quickly to do something about this, but it's something to pay attention to. I don't know that I'd say this is the saving grace. Fundamentally, all of the parade of terribles we've talked about today can be avoided by simply having the requisite level of consent and documenting it. While autodialer rules and pre-recorded message rules and consent rules, those really are a minefield. And Steve, Ellen, and I, we counsel our clients all the time on how to avoid the pitfalls. If you have the right level of consent, you're not going to violate the statute. The three of us have developed a table of the consent rules, for telemarketing and non-telemarketing calls to residential landline phones and cell phones. And we're happy to share the table with you. Just email one of us, and we'll make sure it lands in your inbox.
All right, we have 2 minutes left, so I'll try to get in 2 questions. The first one, we got a few questions, so I'm sorry we don't get to them all. But do these rules apply to business calls?
So certainly the telemarketing sales rule generally does not. There are a couple carve-outs for certain kinds of cleaning products. Certain
durable office
equipment, and it's an issue sometimes. With some of my clients have had it. Telemarketing sales rule definitely does not apply generally to the business-to-business calls, but the TCPA generally does.
And in fact, there's a plaintiff's firm out in Northern California that we have seen pretty frequently. That they're filing a bunch of cases on behalf of a local plumbing business that has been getting automated texts and pre-recorded calls with telemarketing offers to the business lines of the company. We see those frequently. There's probably 1 or 2 a month being filed on behalf of that plaintiff.
It's a Bonte rooter for those keeping score at home.
Yeah.
All right. There are other questions. I'm sorry. They're very good questions, but they actually would require a lot of talk time. So, but we have your questions. If you send in a couple of them, we got some questions about texting back a missed call and very specific questions about lead generation purposes and things like that. And we'll get back to you otherwise. But I think that wraps us up for today. Again, you'll get your CLE code through somewhere along the way. And if you need it, contact somebody. But thank you very much for joining us, and have a great rest of your day.